Okay, good morning, students. Mike Lilly. This is criminal procedure and evidence. We're already nearing the end of the second week in February, and time's moving on. Before we know it, it'll be the spring break, and we can all kick up our heels. Of course, it'll probably snow during spring break, so that will not do much to improve our dispositions. Okay. Yeah, I'm sorry, I'm off to a little bit of a late start this morning, but we had some concerns about some student issues. The last class period, as I recall, once again, we were discussing more about arrests, things of that nature. And we were particularly talking about the automobile exception to the exclusionary rule. Automobile meaning because cars move, therefore different rules have been invented by the courts to cover that issue. I myself find that some of these issues, some of these rules may be a bit artificial, or not certainly the ones governing many of those early cases talking about locked containers and whether or not you could use those or not. I think that's pretty much already been resolved, and so the basic rule today is that as far as a legitimate stop for some perhaps criminal violation, I'm talking about a tail light or an inspection sticker or something of that nature, certainly a precursory search of the car is in order. Now, one of the things, of course, that is true about traffic violations is that there are some, when a person is stopped and perhaps arrested for a violation of those, the car is going to be impounded into a local storage facility. Usually, and again, it depends on where you are, your larger police departments will have their own individually owned impoundment facilities. Basically, here in West Virginia, most simply rely on salvage operator, in other words, a local junkyard that has security that can keep items on the premises locked up. There are, of course, some issues about when a car is impounded, which basically means, right, that the car is going to be towed to the facility where it's going to be put in some form of storage. One of the first things that happens anytime a car is put into storage is that it's going to be entered by the employees. Are going to open up the car, look into it, and make a detailed listing of whatever personal property is located in the car at the time it's brought into the lot. There's a number of reasons for that, the most common being to protect the owner of the car and also the lot management from claims that there was something in the car that was stolen while it was impounded. Now, I'm honest, most of the time when if my cars would be subject to impoundment, the only thing probably in them would be, empty food wrappers, empty coffee cups, or maybe an open coffee cup or something. Not a lot of valuable property, but lots of times we have seen claims, cameras, computers, all sorts of other valuable stuff that might have been in the car, which could have been stolen after it was impounded. So I recognize that there is that necessity for an initial evaluation of what personal property belonging to the owner of the car or any other occupants, that needs to be done on the spot. The next question, however, is even if the car is in a police impoundment lot, does law enforcement have the right to search the car for other incriminating evidence other than what's initially been inventoried? Some question about that, but the rule basically seems to be that such a search has to be accompanied by a warrant to authorize a more detailed search of the car other than that initial inventory. And again, you know, there's lots of different times in which a car could be impounded. Typically, if you're arrested for drunk driving and there's no one else there, right, the car's going to get towed in. If you're driving on a suspended driver's license, they're going to tow the car in. And let me see, what else? Certain other offenses, more likely, you're going to have the car towed in to the lot. Likewise, if your car's been involved in a serious accident, such that it cannot be driven away from the scene, it's going to be towed to a secured lot, and again, its contents be inventoried if possible. Okay? So, again, it's an issue that is probably not too, most people don't think about nowadays, but it does happen. I used to see a lot of it when cars would be repossessed for non-payment of finance fees, that the repo people would, quite frankly, remove what was in the car, either lose it, keep it, or you don't know whatever happened to it. So again, that is an important issue. Okay, now let's see, where else am I? In my discussions about search and seizure and arrest. Okay, I'm sorry, my problem is that I since I'm using the newest version, I don't have it marked up as well as I did before. Okay. Okay. All right. I guess the next issue brought up a number of times about searches and arrests, but more likely about searches is the issue of consent. If police knock on your door and ask you, can they search your home, and you give them permission, and that constitutes a waiver of whatever rights you had to have, that you have right to object to a search without a warrant. So one of the questions frequently on, and which came up with automobiles, was a car is stopped. It's not being driven by the owner of the automobile, it's being driven by someone else. In this case, the owner of the automobile was in the car, but quite frankly, he was incapacitated, and so therefore, that's why he had a designated driver driving the car. Another case involved car being driven on the border, and again, I think the owner of the car was in the back seat. Can the driver of the car give consent to law enforcement to search a car without a warrant when it's not his car? And that question or situation goes back also to questions about whether or not someone can give police permission to search an apartment or a house when they're not the owner of the house. One of the more common ones involved, quite bluntly, two roommates. Okay, one roommate gives permission to search the apartment, even though the other roommate has their own room, okay, which, they keep private. Can that roommate give permission to search the other roommate's room? Even though that's perhaps a bit technical stretching, the courts basically have upheld that right. Again, unless the roommate's room is padlocked or locked so that it can't be entered into by the other roommate. And sometimes we have disputes between roommates, which basically mean, right, that they don't get along very well, and they don't want that other roommate in their room. However, that's pretty much been I don't think is necessarily an issue. Certainly we have cases involving college dormitory rooms, which usually have two people in them, or used to have two people in them. And either of the two could be given permission for campus police to search that dormitory room. And of course, we don't have dormitory housing here at Bluefield State, but that doesn't mean that we won't. Maybe in the near future, who knows? We'll see. So, when it comes to an automobile, therefore, does the driver of the car have permission? Can the driver of the car get permission for it to be searched when they don't own it? Obviously, if the owner of the car is not in the car at the time the question is asked, then that's a give me, right? If the owner of the car is in the car, however, and physically objects to it being searched, then law enforcement doesn't necessarily, unless they have some suspicion that there's something wrong in the car, to further search it. However, most decisions have seemed to indicate that the consent by the driver is good enough to allow searching of the car. Okay? All right. Now, let's switch gears a bit and talk more other areas of suspicion which have been heavily litigated over the years, and that is the so-called criminal profile cases. Now, profiling in more recent years has had a lot of blowback, claiming again that it basically is racially stereotyped, and therefore that a given profile of a suspected person shouldn't be taking place. The original criminal profiling cases came to us out of Miami and Fort Lauderdale. And that's because at the height of the initial cocaine invasion from Colombia, where most of Colombian cocaine was being smuggled into the U.S. through the Miami-Dade airport, or a lot of it. It was being smuggled into the country by individuals we typically call mules. That's South American term, since mules were used for centuries, right, to haul all kinds of goods over narrow mountain paths. So a typical mule in earlier times would be a young college student or a young person who'd been recruited by the cartel to bring in cocaine into the Miami airport. And one of the first cases we had on it involved a drug courier profile which had been developed by Miami law enforcement, which seemed to indicate that there were certain characteristics of a potential drug smuggler. First, they paid for their plane ticket in cash, not by credit card or debit card. Second, they would be young. I think usually under 22 to 18, somewhere in there. Third, they would be carrying little or no luggage. In other words, they did not check a suitcase at the airport when they boarded the plane. So they usually would have only a carry-on satchel when they got onto the plane. Using this, police began stopping people at Miami Airport. And the next third one was that these individuals were traveling into the United States from Colombia or Venezuela or some other South American country, but usually Colombia initially. What's the other one? Bolivia, you know. So, and finally, I forget they had a one-way ticket. Okay, not a return ticket, a one-way ticket. So people who met this characteristic from looking at check-in data at airports began being stopped to see whether they were carrying drugs. Some would be carrying it in their single satchel, right? Others might be smuggling drugs inside themselves as a suitcase, meaning they had swallowed balloons full of cocaine or heroin, which would be extracted after they arrived in the United States from their stool. It's a rather unpleasant thought, I guess, from the beginning, to find where your drugs came from. But anyway, these early drug profile arrests, therefore, were upheld by the Supreme Court because someone meeting that narrow listing of characteristics certainly was initial suspicion to question the individual about, again, why they were coming into the United States, right, and different things. Later on, the drug courier profile is expanded into people driving usually high-end sports cars up the I-95 corridor from Miami to New York City. And that's because, that's right, these early smugglers would want to get the fastest car they could get their hands on so they could outrun police and could get drugs up to New York City in a short period of time. It is said that at one time, the best equipped drivers in the country was the New Jersey State Police, because they all either had an expensive Mercedes or Porsche or maybe a Ferrari. In other words, high-end, high-speed cars which had been seized from drug smugglers coming up and down, again, coming up the I-95 corridor. Well, how valid were those profiles? And again, the chief profile would have been that the particular individual, again, drove an expensive car and was driving too fast. Some real question about that. The mere fact they were stopped for speeding, for instance, I think would justify that. Does possession of a radar detector give enough suspicion for police to stop you in states where radar detectors are legal? Now, in Virginia, the state of Virginia, a radar detector is illegal. Therefore, obviously having one in your car is grounds to stop you. In West Virginia, however, a radar detector is not legal. Is legal. Likewise, having a camera, a front-facing camera in your car, which looks in some ways like radar detectors. Would that give you suspicion in Virginia to stop you? Because it looked like that camera looks like a radar detector. And I think there's I'm sure there's some decisions which seem to indicate that may be true. On the other hand, however, in West Virginia, merely having a dashboard camera in a private vehicle is not sufficient suspicion to stop the car. Why would you want one in your car? If for no other reason to film what happens in an auto accident if somebody runs into you or whatever. Just like you have all cars now made, of course, have to have a backup camera in the car. I don't see any problem with, again, having a dashboard camera to record things in front of it. Anyway, I'm not sure, again, that's necessarily sufficient suspicion to stop you. But going back to the old profile cases, we did have one case involving a young college student who gets onto a bus in Florida at Fort Lauderdale, getting ready to go north. Sheriff's deputy gets onto the bus because they were under the impression that there's smugglers on the bus. They get onto the bus after everybody's gotten onto it. And I'm trying to find my case. And I'll have to give it to you next class period. Anyway, the deputy gets onto the bus, sees this college student dressed casually on the bus, asks him to get up, and then demands that he be allowed to search his carry-on luggage. He does so. The student is initially suspected of being a drug dealer because he doesn't answer questions right. Therefore, they search his luggage, find the narcotics, and arrest him. In that case, the U.S. Supreme Court ruled there was not sufficient cause, even if the drug courier profile said it would be young college students riding a bus, that wasn't sufficient suspicion in that case. Of course, police profiling has changed a lot since those days. And to be honest, Miami is no longer the main port of entry of Colombian cocaine. However, the main issues we've had about profiling lies in the area where people's cars are stopped and searched by law enforcement because of where the car is and the race of the driver of the car. There are lots and lots of people, African Americans, who can tell you that if they have been in a white neighborhood, that there is a likelihood that they would have been stopped by police and questioned as to why they were in that neighborhood. Not because they had a taillight out, not because of some problem with the car, but because of the color of their skin and the car itself. Including, I might add, any number of people who lived in that neighborhood, right? But were still being stopped by police in what amounts to profiling based on race exclusively. Now, the state of West Virginia has passed an anti-profiling statute, which is supposedly aimed at stopping that problem. Whether it really does or not, I don't know. But we certainly have a law which prevents racial profiling in the investigation of an arrest. Anyway, I certainly have some doubts about its effectiveness. However, it's obviously recognized as a problem in this and other states about that process. So my real answer is that if an individual is pulled over because they're in the wrong neighborhood and police have a suspicion that they're there to rob someone, that's not grounds to stop the car or to search it without the consent of the driver. Okay, now let me see, what else do I need to come up with? In these cases. All right. Let's not do that. I'll have to find out more. We'll look at a few more cases next class period. We're going to start talking about so-called open fields doctrine, and finally, then we'll start talking about electronic surveillance. With that in mind, I'm gonna close for the day a few minutes early. And we'll take more up on Mondays next week.